Good evening, everyone. On behalf of the team at HR at 8 p.m., I welcome you all to the 18th episode of ABCDE. ABCDE stands for Academy of Business Consulting, Development and Entrepreneurship. By the way, season 1 was held earlier this year between April 5th and May 1st. The series of lockdowns had just begun, and that's when Indranil Banerjee and Dr. Chinmoy Sarkar started season 1 of ABCDE. Indranil continues to be the brain behind HR at 8 p.m. in season 2, and he's ably supported by a group of dedicated volunteers who work selflessly to bring this brain-enriching sessions every Friday evening for the last 18 weeks in succession. Let me applaud the team HR at 8 p.m. at the very start. The topic for today is Employee Sustainability Framework, Occupational Safety, Health and Working Conditions Code. Our expert speaker is Mr. Vittala Rao, a management consultant. Mr. Rao will be introduced shortly by our moderator, Sheela Mistry. Sheela founded Insights Associates, IA, 1999. IA has been one of the exclusive training partners in India, certified by Global Reporting Initiative, GRI, from 2009 till 2017. IA helps companies in capacity building and communicating their sustainability impact. GRI recognized IA as the leaders in providing their courses. Sheela is an ISO 9001-2015 lead auditor. She also helps organizations in training and implementing POSH 2013. Before I turn over the floor to Sheela, I would like to inform you that this session is being recorded. In order to keep the background noise to a minimum, the mics have been put on mute. Please keep writing in the chat box. In case you ask the question yourself, please raise your hand and your mics will be unmuted. I'll be summing up after the Q&A round is over. Over to you, Sheela, to conduct the session.
Thank you, Atulji, and thank you for the introduction. Good evening to all of you all. You have certainly set the tone of the session. Just to start with, I should say the year 2020 has been a year of reform. This includes even HR fraternity. The HR functions which we have been accustomed to and have been practicing for years together is now going to change. And since the new labor code is expecting to be commenced with effect from 1st of April 2021, this is the most right time to address this issue. And I'm glad that we have expert and seasoned professional like Mr. Vittala Rao to walk us through the one of the codes, that is occupational health and safety and working conditions. Our speaker today is Mr. Vittala Rao, and I'm pleased to, and I feel humbled in introducing you, sir. You are BSc, BL, DSSA by qualification and a seasoned consultant and professional by profession. You bring in 36 years of corporate experiences of HR specialization in industrial relations especially. You have held many key positions in large corporates like Kirloskar Electric Group of companies, General Manager with Goetz India Limited, and HR heads of Triveni Engineering, GKW, John Fowler, Coca, Mail, Myco, etc. For past 15 years, you have been active in management consultant and extending your services in critical areas of industrial relations like collective bargaining, legal opinions, strategic management, corporate restructuring that includes right sizing and downsizing through separation schemes, merger, demerger, union handling, compliance management, legal audits and risk analysis, and so on and so forth. Your regular client includes organizations like Mindtree, Accenture, etc. And you also are supportive to NHRDN and serves as a visiting faculty to B schools, sir. And with this brief introduction, I extend a warm welcome to you, sir.
Thank you very much. Thank you very much. In fact, it is my great privilege to get associated with HR 8 p.m. It's the first time I'm entering into your group is extremely happy. It's my deem it a privilege to come and participate in this great session on this topic. Extremely happy. So I thank you very much. So I will proceed with the presentation. Of course, all of you know that the labor reform topic has been talked of even in the second Labour Commission in 2002. In fact, they encouraged that we should combine the various legislations in different areas and to go ahead with this. Though it is 2002, nothing has happened. Of course, every year, we used to hear about labor reforms whenever a minister makes this budget speech, we used to hear about it. And we used to express our joy, okay, this is the labor reform, what we want, what the industry want. We had several important things what we to tell the government, saying that you remove that, you remove that, remove that. So it is easy to make the business, continue the business and all that we are doing it. But unfortunately, as our experience says, the moment the finance minister makes the budget speech about labor reforms, all of us will get thrilled about it. But after 2 days, the trade unions, they will give a national strike against this, and the whole thing goes to a cold storage. So this has been our experience all these years. But now, at least now, a time has come where the government has taken a lot of initiative in bringing out the 4 codes, is important. As you know that all the 4 codes have been passed by the Parliament and gazetted. It has become an act, but the only thing is date of effectiveness is yet to be announced. That's, and of course rules have to be formed yet, and that's also will take time. That's the reason I think today's newspaper says that by April 2021, the 4 codes are likely to come into force. Now here, the thing is that if we interact, we can discuss later also at the end of the session how far these codes are going to be helpful, useful for any entrepreneur to ease out business. That we have to see this. Because of course I got my own different views because I have studied all the 4 codes and made presentations. But if you look at it, it's a difficult thing to say that it is in favor of the entrepreneurship. I don't think so, because most things are in fact, the intention is that to remove confusions in multiple definitions, make it transparent and all that. But how far the intention have been be able to come effect, that we have to see in this, then only we can understand this. So with this slight background, I will just take it. Of course, this is the 4th code, the Occupational Health and Safety and Working Conditions Code. Here, as you know, the almost 13 legislations have been brought under this code. 13 legislations have been brought under this code. And people who are familiar with the Factories Act or Mines Act or Plantation Act or any of this act whom we are involved, already we have gone through various propositions of the act and connected with rules. All of us have studied for the last 30 and practiced also more than 30-40 years. We practiced it, and it has become a very established industrial law, established practice has come today. But now with this merger of these legislations, how it is merged and all that, let's have a look at it. This is if you see this, some things are better, some things are confusing, and some things are in favor of the entrepreneurship. Sometimes some things it is not in favor of also entrepreneurship. This is the whole thing. So I'll just take you through a summarized version of the code, how it is connected. Now, as you know, it has got 56 definitions and 134 provisions and 13 chapters and subpart 6 it has got, and it consolidates 13 legislation as I said already. Now, if we look at, of course, this is only to consolidate the amendment and amend the laws regulating all what I explained to you just now I told you. But now the thing is that one important thing is the code is applicable to all establishments. Here, all established means what we say is that including the commercial establishments. So far, there is no law, there is no stringent law on health safety and occupational health safety and welfare conditions and all that. It was not available for most of the commercial establishments. You see, all of us are very familiar with shops and commercial establishment. In some of the states, some thing have been incorporated about the safety, welfare, a bit, little bit. But in some of the state government, if you see, it is not there. But now here a code has come where all the establishments are going to be governed by these occupational health and safety regulations and working conditions and welfare facilities and employment of women. Everything have been taken care of in common to all the establishments. That is one thing. I think I consider this a welcome step. Because today, if you take commercial establishment like, for instance, ITAs, BPOs, or any large commercial establishment, not much people, okay, the company may be taking care of them well, fine, that's a different issue. But the thing is, there is no compulsion on anybody that they have to follow this. It is not there. But now a code has come where it dictates that you have to do this, So this applicability is there. Okay, now I'll just take you through a broad layout of the code. I'll just take you this. Now here, if you see here, the first of all, right from definitions to employment domain, registration, duties of employers, occupational health safety, health and working conditions, welfare, registers, authorities, and employment women. This first portion is applicable to all the establishments. I told you already, all the establishments it covers. Now, in short, if we say this, you see, all of us are very familiar with certain, other than commercial establishments, legislation, like for instance, as I said already, the Factories Act, Mines Act, or Plantation Act, or Building Construction Workers Act, all these things, it does contain the duties of employers and employees. It does contain occupational health and safety. It does contain health and working conditions, welfare conditions, registers, authorities, and some restrictions on employment domain. It is there already. But now what happens, for us, it's very easy to understand. It's very easy to understand because already we have gone through these acts and very familiar with that. So more or less the same thing almost will be incorporated in this code in a little bit prescribed manner. This is the only thing. Now, if the separate subchapters they have made, subchapters are the contract labor, interstate migrant worker, mines, plantation, BDCR, audiovisual, building and construction, and Factories Act. They have made specifically for this. For this, there is a separate chapter which deals with this segment of industry. Now, here also, for instance, if I take the Factories Act, for instance, now, in Factories Act, if you read today, it has got very elaborate do's and don'ts and everything, specifications, including everything we find in the Factories Act and in the Factories Rules also. Similarly, in Mines and Plantation Act. But here, what happened is that in this code, those specifications and etc. is not there at all, except it says duties so and so, because everything have been given to the responsibility either on the central government or the Occupational Health and Safety Council, which they are going to form. They are going to prescribe each and everything. In other words, probably, according to me, same replica of the Act and rules may be incorporated in those recommendations in the form of rules, and that may come through. That is the reason why we find in this code the number of provisions are totally reduced. That is the reason. So let us go through this. So this is one thing. And the last segment, applicability of it for all the establishments regarding offences and penalties, miscellaneous provisions, power to make regulations, etc., and then bylaws, rules, etc. That is again applicable to all the establishments. So here what happens in the first portion and third portion is made applicable to all the establishments, and the middle portion is applicable to only for segmented industries, what I told you. So this is how it is. I'll just give a broad picture of it. Now here I will take you to only definitions. If you see this, all the definitions are the same as what we read right now in various acts. But I'm going to highlight the definitions which have been changed or altered. I will just mention that. Otherwise, all the definitions are remain same. There is no change about it. We'll discuss only about the changes in definitions, what has been brought about. Now, first of all, the definition of Interstate Migrant Workmen Act, Interstate Migrant Workers Act, here it is. Now, here, if you see here, the present definition in the Interstate Migrant Workers Act, it is a migrant worker is one engaged through a contractor in one state for employment in an establishment of another state under an agreement or other arrangement for such employment and transfer, so on, so on, so. This is the present definition. Now, what happened in this definition? They have been changed to incorporate this one. An employer in one state for employment in this establishment in other states recruits. So here, I think it's got a little more deeper impact as far as the entrepreneurs are concerned. Today, the employees, if they recruit directly from other states, of course, the thing is that workman category what we are talking about. So if we employ a worker from other states directly by the entrepreneur or the employer, this act was not coming in the picture. But now what happens on account of this? If we directly employ anybody from any other states, he falls in the definition of Interstate Migrant Workers Act. And this has got some implications on us in the chapter applicable for contract labor and intermigration workers. So this is one definition which has been inserted, and of course we don't know why they have inserted this and here. So this is one thing we have to keep in mind. This may have some slight repercussions in our day-to-day workings. This we have to do. Here the definition of industry is same thing as what have been defined in the Code of Industrial Relations 2020. Of course, there also the definition of industry is exactly the same as what Supreme Court pronounced in Justice Krishna here in BW versus Rajapa's case. The same principle, in the sense that systematic activity, engagement of employee, and all these things, the wide definition, what the had, and in fact all the courts have also accepted, we are interpreting it. So same thing have been incorporated in the definition of industry. It means that it has got a very wide application of definition of industry. Now here definition of worker is also on the Code of Industrial Relations only. Now here also, if you see the definition of worker in IR code also, it is same as what is existing in the ID Act today. What is in the ID Act, the same definition here also pop it down. There is no difference in, same thing is there. But now here they inserted one more definition called employee. Employee definition they have included. Here, if you see the definition, it is inclusive of all supervisory, managerial, administrative, everybody is included. It appears in one of the standing committee reports I was just going through there, because the standing committee was of the view that the code must be applicable for all the employees and there should not be any exceptions. Because whether it is welfare or security, whatever you may call, all employees must be covered, and hence the definition of employee have been incorporated. But here, if you see here, I will go further, I will tell you, in certain areas, the word employee have been defined. In certain areas, they have mentioned only the definition of worker. It has got some implications that I will explain to you in shortly, due course, okay? Then here in this, the one more new definition has been introduced called hazardous substance. In the Factories Act, we see hazardous process. Hazardous process we see. But here they introduced the word hazardous substance. Here it appears, sometime back, about 6 years or 7 years back, they wanted to bring some amendment to Factories Act, probably you may recall. At that time, they had introduced this hazardous substance. Here, the intention of introducing this was that if any employer, even keeps hazardous substance in his stock, in his godown, in his warehouse, in his this one, then it is which is likely to cause problems, etc., etc., then it should be taken care of. In other words, that's why they brought this concept here. Now, here also they have used the word hazardous substance. Of course, this is only from the point of view of health and safety and occupational health. So, this has been introduced. This is one thing we have to see. Then here, the definition of contract labor. Of course, this is not a something new definition, but there is some proviso which I will tell you later. Of course, he is a workman who will be deemed to be employed in connection with work of an establishment when he is hired or in connection so and so and so, and includes an interstate migrant worker. So this is very important. Includes an interstate migrant worker act. This is one thing, but they also mentioned, but does not include a worker. See, this is very important and debatable issue. Debatable issue. Includes a worker other than part-time worker who is regularly employed by a contractor for any activity in his establishment, and his employment is governed by mutually acceptable standards of condition of employment and payment of salary, etc., etc., then he is not a contractor. He is not a contract worker. He doesn't include. So this is a quite debatable issue. In fact, I was also debating this, why they have inserted this kind of a most confusing definition. According to me, it is a confusing definition. Not only that, I think this might lead to a lot of what you call debate or even litigations also. You see, I was just thinking myself, it's only my personal view, please don't think the other way. I was under the impression that probably if you interpret like this might help the employer. Let's say, for instance, I will give an example. Let us take an example of a security agency, right? Let us say security agency, he's got his own establishment, and then let us say he on his role, they have got about 500 security people with him. His nature of work in his establishment is management of security. So for that purpose, he has got his employment, employ the security people, and pays the wages, blah, blah, everything is taken care of. Now what he does, he deputes people to various industries, he deputation. You see, I say that I want 10 security people means he deputes those 10 people from his organization to our organization, right? Organization. Now, if this argument holds good, then what happens? The 10 people who are going to work in our establishment need not be considered as contract labor at all. Need not be considered. So this is my personal view on definition. I don't know if somebody can throw a good light on this. Excellent. So this is one little confusing and then not a very, very transparent definition. This is likely to lead confusion. So as I said already, this I may be correct, I may not be correct. And this is the kind of thing. Okay, this one, let us keep it in mind. Then here, for the first time in Contract Labor Regulation Act 1970 came into force, first time they have defined what is a core activity of an establishment. You see, gentlemen, all of you know that the core activity or non-core activity has not been defined anywhere in Contract Labor Act. Of course, we are talking, we talk, we argue, we advance argument in the court, is a core activity, non-core activity, all these things, we have been doing it, but nothing except Andhra government had done amendment about 10 years back. They defined what is core and non-core activities. Other than that, no one has done it. Now, for the first time, they have introduced a core activity. If you see the definition here, any activity for which the establishment is set up and includes any activity which is essential or necessary to carry out such activity. So here, so it's very clear now. It means that it means that the direct activities of an establishment for which the establishment is created, so those activities will be called as core activity of the establishment. This is one broad definition they have given, and of course they have given some exceptions also. They have defined according to the non-core activity, like for instance sanitation, sweeping, cleaning, watch and ward, then canteen and catering services, loading and unloading operation, running a hospital with for the purpose of the organization, education, training institution. All these people have come as what we call exceptions. According to us, it is an encore activity. Courier services, civil and other construction activities, gardening and maintenance, housekeeping and laundry services, and other activities. It has come like that. Then transport services, including ambulance services, any activity. This is very important. If you see item number 11 here, this is one thing which is slightly important in the sense any activity of intermittent nature, even if that constitutes a core activity of an establishment, we can engage in the sense that it becomes a non-core activity. Suppose you got sudden flush of orders, sudden demand of order, we need to engage, let's say, X number of people in the core activity for intermittent working, maybe a short period, less than 120 days in a year, something like that. If you do that, then what happens? This activity is considered as non-core activity and you can engage it. So this is one thing I have done. In case the question comes, what is a core activity, not a non-core activity? The state government, appropriate government shall appoint an authority to decide the question whether activity is core or non-core. Then agreed party may have to file an application in the prescribed manner before the authority to raise whether it is a core activity or non-core activity. So what happens here is, friends, gentlemen, I think this will rake up a lot of debates and issues in any industry. In any industry, a lot of things are going to happen. Take, for instance, yesterday I was talking to some people. I made a presentation. They raised the issue. Let us take an example of a factory. In the factory, of course, in the exception they have said loading and unloading. Loading and unloading means where, that they are not mentioned. Take, for instance, in the factory, after the products are over, before it goes to the warehouse or a godown, it has to be packed, number one, and for that purpose, loading and unloading has to take place. Now, whether that activity of loading and unloading of finished goods to the onto the truck to go to what do you call this one, whether it forms a core activity or not, this becomes a debatable issue. And take, for instance, even that can be extended to anything. In various hangars and shops, we have got a lot of loading and unloading jobs. One hangar to another hangar, another hangar to another hangar. Again, there is a question of loading and unloading, whether that will constitute a core or non-core activity. Now, again, friends, this all becomes a debatable issue according to me. So what happens is that, so I think we'll be flooded with a lot of argument litigations may be there because it's not very precise and clear. It is a little bit vague. So this is one, the definition just come like this. Of course, as I said already, interstate workman definition, I told you already, it includes the directly employed by an employer. In the definition of contract labor includes interstate migrant worker. All these things are overlapping in here. Of course, we'll see what the next chapter in the chapter what it applies. Now, when you come to the registration of establishment in chapter 2, of course, they have said that there shall be one registration and all the establishments shall be comply within 30 days. Of course, again, the rules had to be set for this, and then the rules have been prescribed. How, when, and all that it has been done. Now, for instance, now we have already got a factory license or license for some other establishment. Whether that is taken or this is taken, the rules have to say, and we have to wait for it. So this is one thing where what the registration is there. Now here, if you see here, the duties for employees and employees, as I said already, indirectly all these things are present in our existing regulations in Factories Act, Mines Act, Plantation Act. Now here also, they have given a very broad, headlines, broad headlines in this one. Workplace is free from hazardous, it's called so and so and so. Then comply with occupational health and safety standards made under this code. So unless till such time, the occupational health and standards are set up by appropriate council under this, it is all not known. But today, in fact, this act, it is very clear. As you know, the moment we open a book, it says very clearly. But now we have to wait for the notifications to come. Annual health checkup as prescribed by state government. The annual checkup have been introduced for all the employees. Again, he had to wait and see the prescription, what the government is going to prescribe. Are they going to mention health checkup for all the employees, irrespective of whether it's commercial or non-commercial or manufacturing, or are they going to limit to some people? Again, it's a question of debate, and we have to wait and see. Next is that issue of letters of appointment has been made compulsory to each employee as prescribed. As we know, there is no law here anywhere that we need to issue a letter of appointment to anybody. So far, there is no law. But now, of course, in some of the state government, state Shop and Establishment Act, something has been mentioned in some of the states. But here, it says here, all employees shall be issued with a letter of appointment. This is one thing. And here, duties of employees also have been made. And again, all these things I have put in the headlines, but only thing is the descriptive portion of it. Descriptive portion of it, we have to wait for the rules and regulations to come. In that, we have to wait for the council's report, safety council's report, what they are going to prescribe, everything we have to see. So this is one thing which is made common, and bullet they have mentioned, but now this has to be wait and see how it happens. Now here, there one more thing also they have introduced, duties of manufacturer, designs, importers, suppliers also to ensure all these things. Of course, to a certain extent, if you see the Factories Act today, it is there. But now what happened is that I think more emphasis has been given on the part of the manufacturer, designers or importers or even suppliers to ensure that when the end product is used by the customer, that should not create any kind of health issues or any hazardous for the people who use it. If that happens, then the people will be held responsible. So this is one thing. And if you see here, if you see point number 6, even for architects and project engineers, designers also have been elaborately prescribed. It means that what happens, even a designer or a project engineer, designers have got now more responsibility and becomes accountable under this code. So this is one thing which is imposed right in this code. Of course, we have to see the details, rules, etc. when it comes here. That we have to see. Here, for all these purposes, a national board shall be formed. It is called Occupational Health and Safety National Board. Now here, all these things what we just went through now, the standards, rules and regulations to be framed under this code, they have to do it. Right now, of course, as I said, repeatedly say that if you read Factories Act, it gives a very clearly, we need not do anything, everything beautifully worded, beautifully prescribed. The rules, everything is beautifully prescribed. But now we have to wait for see, and are they going to copy down the same thing, or are they going to revise it? What are they going to do? That we have to wait and see. So this is going to be a very elaborate one when the national board takes up, and it is their responsibility. They have to do it. And of course, the constitution of national board also, they have been mentioned in the code for the representative for the people. And a lot of some experts, everybody have been included in the recommended in the council. That is different thing. So this they have done. Then here also, similarly, state also is required to appoint state advisory board by the state government on the same thing, appraisal committee, and consisting of equal number of members. All these things, the state boards also have to constitute on the same thing, and they need to advise the state government and what are the things to be done in this respect. They also keep an advice and they elaborate it. Then occupational health standards, again I repeat that, of course this is a repetition more or less. The health and safety board, they have to do this. Central government should declare by notification standards of occupational health and safety for so and so and so, related to mines, dog, etc. Research related activities, and here one thing I see here is that occupational health and safety survey fine. Safety committee and safety officers Right now, I know, as you know, it is all limited to manufacturing, plantation, mines, etc. But now with this, even the big commercial establishments, with the requirement what they're going to specify, I think this also will be there. Safety committee and how to appoint safety officers, what is their qualification, experience, everything. Even for commercial establishments, I think this is going to be imposed. This is one thing they have done it here. Then, of course, this also has been incorporated in the same factory sector and the rules. We have seen that the responsible employer in maintaining health and working conditions. Right now, it is there. Now, here also we reiterated, shall be responsible to maintain the established health and working conditions as prescribed by the central government. Now, right now, they are not prescribed. We have to wait and see what they are going to. Probably, in my view, probably what they do is that probably they will make. Probably it will just copy down from the same, whatever we have in these legislations, may be incorporated in the respective chapter. Most probably it will happen. With slight variations, it may be there. That's what happened. Similarly, welfare facilities. The welfare, right now we got facilities for these things, but now commercial establishment, there is no mandatory welfare facilities. Now here is going to come again here, the central government shall prescribe what are the safety welfare facilities, all these things they are going to prescribe this. So it is going to be very voluminous one. Now here again the working conditions on annually with wages. This has been standardized now. Standardized in the sense that because this is applicable for all the establishments across everywhere, everything remains same. Only weekly off and all the things, yeah, whatever exists now, same thing be repeated, same thing is repeated. And only change is that right now in Factories Act we have for the eligibility for annual leave is 240 days. One should put in 240 days, and previously preceding 12 months he has to put it. But now that has been reduced to 180 days. That's the only thing. Otherwise, the other conditions of granting leave, etc., everything is just replica or repeat of the same thing. There is no change except this change from 240 days to 180 days. That's all the change. Nothing much has happened here. Now, for the overtime rate of wages, it double the rate. Now here, one thing they have mentioned here, provided no worker shall be required to work overtime by the employer without prior consent of the worker in writing for such work. Now, this is a new insertion. So far, we didn't have such a provision in near the Act that before we ask a worker to work, we need to take a consent. There's nothing, no restrictions were there. But now what happens is that we need to take the consent of the worker. You see, many times, we say that allotment of work is depending on the exigence of work, depending on the requirement of work. In fact, in standing orders we mentioned, the worker shall not refuse to work overtime. If you refuse, it should be considered as misconduct within provision, blah, 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 everything. We have mentioned it. But now what happens is this. For everything, we need to go for consent. Even to work on overtime, we have to get a consent from him. So this is one little impediment, according to me. When day-to-day working in shop floors, this may be a little impediment because consent is required. Because many times, trade unions will influence. Supposing they have got some kind of a rift with the management, one union issue, they will tell the worker, hereafter don't give your consent for overtime working. Let the production suffer. Don't worry, don't give consent. Then you are stuck. So these kind of practical issues may happen on account of this kind of a small insertion here. Of course, these rules and regulations, registers maintained. Again here, it is prescribed that we have to see what they are going to prescribe. Now, employment of women, of course, this is a welcome step, what they have done. As you know, that a lot of controversy were there in the employment of women in the night shifts. We know that. In fact, probably you also heard of what happened in the case of Madras High Court, in the case of this one. They said that it is against the fundamental right of a women employee to restrict her from overtime working. Hence, the Section 66 of Factories Act itself was made null and void at that time. And not a bit. But now, of course, Or to this, many state governments have eased out in the sense that they can work in the engagement of even in the night shift, provided you have to follow a protocol in the sense lot of security and those conditions we have to keep it. That's there. But now it's a good thing they have what you call legalized, regularized it in the sense that you can engage. Well, the conditions will be prescribed by the government, specified by the government. Probably what is the same conditions what we are following now in various models. I think probably 99% the same thing will be there. I think that's a welcome step. That's good. Of course, prohibition when in dangerous operation, of course, is prohibited. That's from various point of view. That's not correct. I think that's okay. That is fine here. Now here, what happens, under each chapter, what we have gone through all these things. Now, the state government shall notify the terms and conditions of these conditions, specifications, parameters, and steps and validation of equipment, machinery, etc. And records will maintain everything to be notified and prescribed by the central government or Occupational Health Safety Council or state council or state government. They have to prescribe. That is the reason, gentlemen, many of the provisions in these acts, we don't find that. That's why the number of provisions have come down, because all these things are eliminated here. But now again, it is going to reimburse in the form of rules and regulations. It will come that way to wait. See, that's going to be, I think it's going to be big, voluminous document only, no doubt about it. Now we'll come to the chapter on the contract labor and interstate migrant workmen. Here one thing is out that the limit of 20 have been raised to 50 to register and license the contract worker. From 20 to 50 it has made. I think let's say, okay, liberal view. And the state government also has the powers to either to reduce it or increase it. They got powers have been given to them. That has to be taken care of. This is one good thing. Now here, the contractor who falls required to take license from authority. Now here we have to wait and see what are the conditions they are going to prescribe by central government while giving a license. That we have to say it and see what are the conditions they are going to put. The license shall be issued on work-specific license. Work-specific. It means that for license for which we are taking for a particular work, that it will be mentioned and we have to use it only for that purpose. Right now, practically all of us know how people use it also. We call it housekeeping, but we put them on something else. We call them loading and unloading, we put them on something else. We do that. But now hereafter, I think it will be work-specific licenses. We need to wait and see what they are going to do. And also they are going to, the contract workers contractors had to deposit the amount to security deposit with the authorities, and validity is 5 years. Now today we have got every year he has to go for renewal. Now it is 5 years, unless of course if amendment has to be done in between, of course subject to that, otherwise the license is for 1 year. Of course, responsibility principle remains same. Whatever we see in the present Contract Labor Act, same thing is copied down here. Responsible principal employer in providing facilities of canteen and payment of wages to contract labor. Same thing can be repeated. It's our responsibility. And if there is short payment or no payment, etc., then principal employer has to pay, and then it has to be recovered from the contractor. Same positions here also. It has been incorporated here. Now this is one important thing here. Of course, right now it is also in a present Contract Labor Act. Section 51 says that if you engage contract labor for a non-licensed contractor, it should be deemed to be contravention of this provision of this code. This is what I have mentioned. It's a contravention of the provisions of this code. Again, I think this is going to be a little bit debatable issue, Probably if I quote, there is one Bombay High Court decision some time back, about 7 years back, where the Bombay High Court discussed thoroughly in one case where the contractor had not taken license and there was no registration by principal employer also, and these people went before the court for litigations for absorption. There, the High Court commented very clearly, saying that look at the fate of the people. What are the fate of the people? They're hanging in between. Neither the contractor is responsible nor the principal employer is responsible, and the contract labor is just hanging in the air. So we don't allow that. They have to be deemed to be the employees of the principal employer. So this is the kind of thing. Now, if we have keep that in mind, we don't know what's going to happen here. We have to wait and see. Again, it is debatable, and a litigation point of view, this may be an issue. We have to be careful and all that. Now, here, different gentlemen, this is the most important thing as far as I want to share with you. Right now, we have got Section 10 of the Contract Labor Act, that prohibition of contract labor. We have that. All of you know that the process of prohibition, it will go through the state advisory board, and they have to debate, discuss, pass a resolution, and then recommend to the state government or central government. The government may agree or may not agree, and if they agree, yes, the prohibition will go through a gazette notification, etc., etc. All these things, all of us have seen in our past experience. Provisions, etc., have been made. Now here, what happens is that if the Section 57 of this code, there is a straight prohibition, no question of going to advisory board or central advisory board, government making a notification, nothing is there. It is a straight prohibition, notwithstanding anything contained in this part. Employment of contract labor in core activities of an establishment is prohibited. See, this is a very, very, very straight hit on enterprise. So it means that you cannot employ any contract labor on the core activities of an establishment. So this is a straight system. It means that I think this will have a lot of repercussions on whatever things for the employers in all areas. This is one thing which is going to hit. Of course, they have made some exceptions. If the normal function establishment is such a way that activities ordinarily do to a contractor, some miscellaneous items, activities such that do not require full-time workers for major portion of an directive. Say, for instance, you engage people for part-time, hourly basis, etc. Probably, I think one can take an exception. And the sudden increase in volume of work in the core activity which needs to accomplish in a specified time. So here what happens, they are given a little bit slight liberalization, in the sense that sudden volume of work, even if we engage a contract labor in the core activity for a specified time, they don't come under Section 57(1), and there is no question of automatic prohibition. It will not come. So this is one slight thing happen, but it's only a minor relief. According to me, it's a very small minor relief. This is exactly. Now here, as far as the interstate workmen and contract labor is concerned, here even for the interstate workmen, even contract labor, we have to ensure suitable working conditions first, having a resort to here. Of course, anyway, we are doing it because they work in an establishment, we have to take care of them in all respects. In case of fatal accident, serious injuries to any such worker, to report these authorities to the state and next, that also we have now. To provide and maintain suitable residential accommodation to such worker during the period of their employment. Now, right now, this condition was put on the contractor under Interstate Migrant Workers Act. Now, since the definition has been amended to include a worker directly recruited by an employer, what happens, here, if you see point number 3, we need to provide housing accommodation. If we engage anybody from outside, we need to provide engagement, housing accommodation. That's another thing. And of course, provide medical facility, periodical checkup. Of course, these things are there. And again, they say it's free of charge. Of course, if it's covered insurance, that is a different thing. Otherwise, it is going to be free of charge. And secondly, this also has been put on us. displacement allowance. Right now, the contractor was made to pay this, but now here what happens? The by employer through contractor, displacement allowance, then journey allowance, all these things, it is an additional responsibility for the people. Maybe it's a good for the worker, there is no doubt about it. It's for good for the interstate workmen. All of us have seen in the COVID thing, what are the interstate workmen suffered quite a lot. That's a different thing, but that's a good thing. But only thing is all these things create heavy liability on the part of the employer. This is one thing. Now, this is about the, coming to Factories Act, of course, the detailed provisions have been made in the Factories Act, only in case of, they mentioned it, but again, to be followed by prescription to be framed by rules and regulations on this by the state or central government. It has, so like for instance, approval of plans, liability of owner, power to apply the code in certain provinces, dangerous operation, constitution of appraisal committee, compulsory disclosure information, specific response in relation to hazardous process. Today we got a big chapter in this in Factories Act and other thing, but today what they said, a small thing, it will be as recommended by the Safety Council, Occupational Health and Safety. I put it like that. The National Board to inquire certain situations. This is exactly what they have done. Then even emergency standards, permissible limits for exposure of chemicals and toxics, right of worker to warn about imminent danger. All these things are existing now. Under the same Factories Act existing, same thing have been repeated here, nothing different, nothing special about it. So in other words, if you see the entire code, almost about 90% of the provisions in the existing legislations have been incorporated in this code. Nothing new, nothing different, except that many things are left open for to be notified by the government, prescribed by the government, and all this we have put it. So this is how it is. Now in the schedule of the Act also, I mentioned the list of industries having hazardous process. Same list have been copied down. Then list of matters pertaining to health, safety and testing equipments, all the matter connected with these have been listed. What they have done here, today in Factories Act and rules we know, the testing equipment, how shall be certified, what is the periodicity, who shall do that, all these things we built in the Act and rules itself. But now what they have done is that they have mentioned as an item, for all these items, the National Occupational Health and Safety Council, they have to prescribe. It means that we have to wait for these notifications. So this is another thing, what we have to wait and see what happens. List of notifiabilities, of course, there is nothing different, same thing they have copied down. Now here there is one more debate in the sense that you can also think about it. This is again my personal view on this. See, right now in the Factories Act, if you see the definition of worker in this one, it has been inclusive one. It means that all persons engaged directly or indirectly, without or with knowledge of the occupier, he is a worker under the Factories Act. And in Factories Act today, everybody is a worker, except occupier, everybody is a worker under Factories Act today. But now what happened here in this chapter? In this chapter of factories, there is no definition of worker separately. The worker definition, we have to refer the, the original definition, what I explained to you. Worker is so and so as defined in the ID Act, that's all. Now here, in the other thing is that the word worker has not been mentioned in this chapter at all. It is not mentioned. Then the question is, what happens to the position of contract labor and supervisory and managerial person? Are they going out of the purview of this application of this chapter? Is a big question. Is a big question. I don't know why they have done it. So this is a big question, and this is one anxiety. Second thing is that this also what I have noticed is a point to be noted in OT payment of OT allowance. At present, in the Factories Act and in various all the legislations we see, they have defined ordinary rate of wages. Ordinary rate of wages is nothing but almost gross wages in all terms. Of for all of your norms. Now, under this, wages have been defined as defined in the Code of Wages Bill 2019. And you probably have gone through what is the definition of wages under the Code of Wages. There another little bit complicated definition they have put it, a very complicated definition they incorporated. If we, according to that definition, according to rough estimate is that it amounts to almost 50% of the gross shall be the wages as per the code. Approximately, I am telling you, 50%. Today, what happens in the OT allowance? Again, I have mentioned overtime should be based on the wages. So, wages definition we have to go by this one. So, it means that we have to pay on 50% of the gross. Look at the present definition, it's almost the gross. So, don't you think the worker will get less in the OT payment? So, when they see that we are going to get less amount on the overtime hereafter, and again there is a consent for them to work on overtime, the apprentices are, do they come for overtime work at all? Why they will come? So this becomes a debatable issue. This is my personal point of view. People can definitely debate and contribute on this issue, no doubt about it. Of course, the penalties are very severe in these chapters, very severe. Of course, in all the codes, the penalties are very severe. Here also very severe. It talks about, always talks about 2 lakhs, 3 lakhs, imprisonment up to 5 months, 6 months, and even 1 year in certain cases. So the penalties are extremely severe. But of course, they have made one provision for certain things, a compoundable one. It means that it's compoundable. One can always decide, pay a certain amount as compromise, and then we pay and pay benefit. This is one thing. Is compoundable. And of course, the common license for the contractor and factories in section 111 they have mentioned. So here, I think we need a lot of clarity in the rules and regulations. We have to see this. So this is one area where we have to see. See, gentlemen, my request is this: when the draft rules are announced by the government, I think all of us have to go through the rules very meticulously, and we should not leave the opportunity to file our thinking or file our views or file our objections, whatever it is. I think it is our duty to bring it to them, bring it to the knowledge, extremely important. Probably, for instance, probably we will also see even the, what you call, under the Code of Wages Bill and the Minimum Wages Act, if you see the rules, they have listed only blue-collar employees in the schedule. Now, what happens to the white-collar people in the code? These are certain things. A lot of anomalies will come. We need to object. So here, my gentlemen, my request is that when the rules comes into force, comes into a draft position, then we need to thoroughly examine and do whatever we have to file our objections. We need to move on this. So this is a broad, broad layout of the entire code I have presented you, with highlights of what is some confusions or do's and what is apprehensions and what is this, all these things I have just put you behind this. Of course, nothing much, because everything has been copied down from here to here, nothing much to carry out. But this is the broad thing I have done in about this time. Now, I think I leave it to the floor, then you can give your views and then we can discuss on that. So thank you very much for having me a patient hearing.
To start with, I will just request Vittalji to kindly enlighten upon because there will be so many clarifications that will come into the rules, that forthcoming rule, which is expected by next couple of 3 months.
Yeah.
So that is one way. But as a whole, as you are into the industry for more than 4 decades, what is your general take? Because all the acts which are almost running for 70 years, okay,
yes,
those are being, they are clubbed together.
Yeah.
And now we have also Contract Labor Act, which is also early 70s, 71.
Yeah.
So again, that is also 50 years old.
Yeah.
So all this 14 acts are being clubbed for this code.
Yeah.
How you take the industry is taking help out of these things? What is your take? How industry is going to react?
Yeah, see, the thing is here, for instance, the main purpose of the central government was to, number one, to ease out the business by eliminating what they say that number of returns, number of registrations, number of documents to be done, and they should be definition, everything should be very transparent and clear. That is the intention of the code. But according to me, if I see all the codes, including this code, I think the purpose is not served. I'm telling you, because if you see any of the, it's not transparent at all. All the things what I have quoted you just now, everything is highly debatable, and many things are not in favor of employer because it is not objected towards the doing is easy business. You're doing the easy business. That's what they say. But I don't think any of this thing is happening because everything, whatever you take it, it's again. Actually, there are no necessity because, for instance, now all the, as you rightly said, all these licenses have been established in India over a period of time, and then all of us, including trade unions and the workers, everybody has become an expert in the present area. And there was no difficulty expressed by the employer. What employer said that was that, okay, we need to have a lot of relaxation in terms of, hire and fire or everything. That's exactly what we are talking about. Even that, of course, except a small portion of liberalization has been given from increasing 100 to 300 people for layoff or enrichment. Otherwise, nothing much. All restrictions are still there. If you take Section 9A of the ID Act, the same thing has been copied down here in higher code also. So that way, it is not that beneficial, and it is going to be.
So sir, if it is not beneficial for the employer,
yeah,
is this code will be benefiting the employees?
Definitely. Because let us take the example of wage code bill. Of course, though it's not a topic today, I'm just telling you for this. Wage code bill. Wage code bill, I'm telling you, of course, it's a good thing, no doubt. I mean, everyone should get the fair living wages. There is no doubt about it. That's a different issue altogether. But unfortunately, what has happened is that the formula what they have suggested for arriving at the floor level minimum wages is based on the criteria of Dr. Arkwright, which says a 2007 calendar survey, etc. All these things they have said. Now it almost come to what you call is a need-based minimum wages, according to theory. The need-based minimum wages must be based on two things to be always taken into account. Number one is the productivity of labor, and second thing is the capacity of the employer to give. See, that is totally absent. Now, another thing is what they have said in the report, they have removed all the scheduled industries. Right now, we have a different industry. For instance, even cottage industry, small scale industry, bigger industry, whatever. We have different rates of minimum wages depending on the nature of the industry. But today, what happens out of this? An unskilled labor, let us take in a very MNC, and an unskilled labor arranged by a garage owner or a small owner, it is same. Here, look at the capacity. Whether the people can afford this is a question. See, from this point of view, of course, no doubt about it, does a good job, do good thing for the workers and living, that's a different issue. But how the industry can sustain this one? And even to take the bonus act, they are not even mentioned what is the limit. They are not mentioned what is the criteria. Everything left.
Okay, sir, I understand. So my final, this related questions is, if it is not favoring the employer, it is favoring the employees.
Yeah.
In between the HR professional, or more specifically, people who are handling the IR of the organizations, they now they will be in the crossroad.
Yes.
How to negotiate on behalf of the employer, and also to protect the interest of the employees which is in rising. Okay.
Yeah.
So how it will be impacted the HR professional who are handling the IR of the organizations?
Actually, in fact, you brought out a very, very important issue, very important issue. Here, actually here, if I talk about the role of us, the role of HR is going to be very, very responsible. Because what happens in this situation, the HR fraternity have to, there are middle between the employees and the business. That is the kind of thing. It's not employees and the management. That concept is gone. Today we are a link between the business and the employees. Employees is including everybody, including the management. So we have to link that. So here what happens, the thing is that how far the HR will inject the business needs into the employees, including the management, is the toughest responsibility for HR. It is not a mechanical one. It's not a mechanical one. Because by business, what happens, one has to forecast what is going to happen next 3 months, what is going to happen next 4 months. Then how do I prepare it? How do I prepare the strategy? Then how do I convince the people? So here what happens is that HR roles become very critical and more responsible because one has to develop a lot of skills in it as competencies. Competency in terms of communication and then competency in understanding everything. He should have the competency of everything. He should understand the business. He should understand market. He should understand the costing. He should understand each and everything. Then what happens, he becomes a master. When he becomes a master, it will be easy for him to convince everybody, including the management or the labor or the. So what happens, he has to play a great role in understanding the whole thing and transmitting in his own skill and techniques by what you call developing emotional, relationship with everybody, and it will be highly transparent and highly pragmatic. It's a great role. This is exactly what I feel the role is going to be. It's not that easy.
Do you think the transition is going to be smooth between existing enactments and the codes? There will be a transition.
Yeah, that's true.
So would that be smooth? I guess it will be challenging.
I know it's a very, very tough question what to ask you, madam. The thing is that I think it is going to be, it is not going to be easy. I can tell you very, very clearly. It's not going to be easy because what happens, let us take the example of today, the topic what we have talked about, the abolition of contract system in core activities. Now, let us take the example of course, in Bangalore, I'm taking you, of course, in a way which is there. In Bangalore, there are many, many big auto industries where they're engaging almost 50% on the production, the contract labor. On the 50% of the people they're engaging on contract labor, and big MNCs in Bangalore, they're working like Honda Motors, there are so many people. Now, what happens when this comes into picture? The first thing will be the trade unions will take up that. So look at this section 57(1), you can't. So we have been asking you since a long time, you please do it and absorb it. So what happens? This is going to be a major challenge. It's a major challenge. I don't know how the industries are going to face this kind of issue. This is one thing. And secondly, in terms of wages also, because what happens, even the fixation of wages on this elaborate formula, of course, they have made region-wide recommendation, but again, they have to be reassessed. And again, we have to go for urban and rural validations. The thing is that how far the trade union leaders are going to appreciate and understand the formula, even an ordinary worker, how will they understand that? So this is a major challenge. Now, forget about them, even for us also, even for the management also, we need to understand the whole mechanics. We need to understand the whole for how they handle it. So according to me, the transition will not be that smooth. It will not be that smooth. I think we'll have a lot of rough weather, I think. Because as you know, already November 26th, all the trade unions, they are staging for a national shutdown. Why? I don't see. The other thing is, they're not coming out. Why? Why? No reason is given. They say we'll go on dharna, But why? What is the reason? They are not coming out with that. See, the emotion, what happens, the transition will be, according to me, it will be a very tough one.
The thing is, the HR fraternity has to roll their sleeves and hone their managerial skills, I guess, you know,
Yes.
to bridge between the employee and the employer. So that's going to be tough task.
Very tough. Now, I go one step further. I said already, you know, a HR will be between the business and the employees.
Yeah.
It not between management and employees, now business and employees. Many times, you know, we have to advise the management also to what is right, what is wrong in terms of business. That's the kind of thing.
Look, how will this work, especially in this, post-pandemic, when people are saying there will be a lot of work shifting to home?
Yeah.
So, and like say you talked about a designer and an architect as being the new definitions that have come in, and those people will in all probability be working from home if this thing continues for some time.
Yeah.
How will this act apply for people at home who may be doing office work, and if they have an accident, what happens?
See, here I can roughly tell you what is the position in the sense that today people are working from home in various sectors of this one. As you know, it's very common. But now what happens, and if you read the legal perspective of this, the working from home is nothing but a notional extension of workplace. That's all. A notional extension. Instead of sitting in a premises, he is working from home. That's all. He is like an outsourced worker. So what happens, you know, even though a person works at home, we will be responsible for any kind of happens. We will be responsible. For instance, you know, he may undergo a lot of stress while working home, or he may, because sitting for a very long time, he may get some, probably he's not sitting in a proper place, he may get a lot of back or related issues he may get. So those issues will be responsible. But of course, now today, industries are not focusing towards that, but now a time has come. If it is going to continue for a long time, we need to feel focused because there's nothing but a notional extension of workplace. So it will be there, there's no doubt. Yeah.
Yeah. The other one is, with there's talk of robots and automation and a whole lot of other machine type of work coming in where the automation will happen.
Yeah.
So now the new skill has to be how humans work with robots to get some done.
Yes.
In the manufacturing industry.
Yeah.
And if we were to compete with China, then that's going to be one of the major things to look.
Yes.
Does this act really define what a robot is and how will it interact with a human?
No, unfortunately, the courts have not eased out the problems of employers. I can tell you very simply. Because, of course, right now, you know, we have learned ourselves for the last, right from 1991, we have learned how to automate, how to rationalize, how to report. We have learned by practice, by change management. By adopting change management practices, we have been doing it because we talk very frequently, talking, convincing, talking. We have been successfully doing it. I think the same thing has to continue because the law has not helped the entrepreneurs at all in this code. If you take the code, an IR code, the change in working conditions, what is in section 9A in the present act, same thing has been copied down there. So it means that if we don't want to discuss with them, officially want to declare means again have to go through a notice to be given and all litigations will start, everything will start. So here is an ongoing process. But I think we have to continue our own change management system to prosper and live, but we can't depend on this code. This will not help.
The third question is on, you mentioned about the code activity of an establishment. I mean, that has to be registered with it and supposed to follow this. But then entrepreneurs, especially startups, they are supposed to pivot a lot, changing market conditions. I mean, for an organization like say Wipro, it started off as an oil and a soap making company and landed up in software somewhere.
Yeah.
So how does this thing would apply in the current environment if a new Wipro were to come in?
See here, as I said already, the whole debate take place. X activity, is it a core activity? You see, we have to narrow down that. You see, in fact, I go into the extreme of this one. I was just imagining myself yesterday. Let us take the example of a software company. In a software company, what happens is we have got software engineers who do regular work, etc., etc. And also, we enter certain work to contract labor also by way of sourcing. They also come and work. The type of work what they do, those people what they do in the same premises. No, whether that activity is a core or non-core. So this becomes a very, very critical affair. Very critical affair. According to me, yes, it means because he is also a software engineer and he is also a software engineer. Definitely it's a core activity. Then what happens? So like that, what I suggest is that any activity we need to thoroughly examine and correlate with the business, with the main activity of the purpose of the establishment, how it is connected, whether we can bring some kind of a linkage, we have to develop some kind of a logic or steps to address this. Then we can strengthen our position. Otherwise, this becomes a highly debatable issue, and then, as you said, it becomes a big problem. It's going to be a big problem.
During this pandemic time, the IR problem will increase. And will this code help to pacify the same?
No, I don't think so. Because what happens, I tell you, whether this code is there or not, we have to manage IR situation in a way what we are doing now. Particularly pro-COVID period, and particular period, handling of IR is extremely important, because here what happens, we need to keep the aspirations or emotions of the workers and the union at a low level. That's our job. Second thing is that in order to address the business requirement, we need to think of what you call flexibility in deployment, multiple operations, this one. So this we need to focus on cost reduction. See, what happened in pandemic, that's the kind of thing. So here, the code is not going to help us, but our own, strengths in handling IR situation, what we have done so far, it has to be a little strengthened, particularly in pro-COVID areas. It has to be more strengthened, because nobody can afford a shutdown or a problem in this COVID area, because every day is important for the business. Every day is important. We can't afford that. For that purpose, not that we compromise, but we need to manage the IR institutions. Is a very critical affair, very important during this period.
Yes, sir. I have one question. I belong to safety profession and in IT industry. Actually, sir, I missed the first part of your valued session. So sorry for that. So I have this doubt now. Suppose for this core activity and non-core activity, I tell you an example. For these IT offices, we have software professionals working at their workplace, and we have also maintenance people, facility people who are under contractual staff. Kind of they are maintaining DG sets, facility, sewage treatment plant, and all these utility area. So will there be any difference of, like safety provisions of the workplace given to the direct employee, which are for the kind of like software professionals, and the safety provisions from the employer responsibility point of view given to the contractual employee who are relatively towards the kind of a high risk, exposed to the high risk work?
Definitely, because what happens, see, there are two things. One is that it is number one, if you see the early portion of the presentation, the employee is responsible for safety, health of everybody. That includes everybody. It says employee, that's a different thing. Now here what happens, even otherwise, we have got a vicarious liability to take care of this. Let us assume that the code is not debatable. But the thing is that the question is vicarious liability. Because that X, who is the contract worker, he is doing the service for the company, for the business of the company, whatever the name, whatever the nature of work he do, he contributes. It means that there is a vicarious liability. It means that for any do's and don'ts or any injury happens to him, vicarious liability says that the master will be responsible. It's a question of master and agent, master and servant context. This is an old legal theory where we become responsible. So here also in this context, definitely, although he is working a non-core function, non-core area, we are going to be definitely responsible for all these things. Definitely, there's no doubt about it, we are responsible.
No more questions now. Can we request Atulji to sum up the session, please?
Yeah, thank you, Sheela. Mr. Rao, what do I say? This is so much of wealth of information. I don't think I can sum it up really, but I can just give you, or to the group itself, my own observations that yes, this act is like 56 definitions, 134 provisions, 13 chapters, 6 subparts. Oh my God, that's quite a lot to assemble anyway. And I wouldn't like to kind of go on the basis of what you have said. The recording will have all the presentation that you have made. So I won't get into that. What did concern me, and I think everybody should be concerned about, is of course the many things are yet to be prescribed by the government. That's a pretty serious issue, and I think it should not have been left hanging. The definition of worker is causing a concern. Yes, very much so. And the overtime work requires prior consent in writing, may lead to some very practical issues, especially when we are all really getting very enthusiastic about taking over work from China. And some of this requires an easing out and ease of doing business, as you said earlier, that we need to kind of get these things done. And the question that I raised about being, worker with robot, etc., that's a future-looking statement that we need to incorporate in our laws. And in fact, I did not see that come through. Of course, you have given me some explanation regarding it. But then as an HR community, I think this is a bit of a challenge here to take forward, because if we can't look into the future and match competing other countries, I'm told Vietnam is really doing pretty well, but we need to relax our laws and make it easier for our business to carry on. And India has that potential with this demographic dividend, etc. Skilled people and ease of movement of labor from one state to the other. All of this has to happen with a nationalistic viewpoint rather than just protecting either the employee or the employer. It has to be more holistic. I think that's one impression I got. And thank you very much for enlightening me with this information, because I did not have this when we all started with this talk. So thanks for your time. And
thank you very much.
Expertise.
Thank you very much. Thank you everyone for giving an opportunity to share my thoughts. Thanks a lot. Thank you. All the best.
Thank you, sir.
Yeah.
And a formal vote of thanks. Can I invite Mr. Anindya Chatterjee, please?
Thank you, ma'am. Thank you, Indranil. It's a wonderful program. Thank you to all audiences, and thank you to Rao sir. Thank you very much.
Thank you very much. Good night. Good night.
Good night.
Yeah.
Namaskar. Have a good week.
Namaskar. Thank you.